Good evening, friends. Myself, Nisha.
And CA Shraddha.
We welcome to you all on today's live learning coaching classes on your paper 2 of your syllabus, that is corporate and other laws of the intermediate level. Dear friends, when we talk about the intermediate level, what is the basic requirement? Yes, you have to grab the knowledge with the proper working knowledge. Working knowledge in the sense you have to apply the law within the given circumstances. And in today's session, since we are now about to start the other law portion, so already you are through with the objective, with what intent you have to read and understand the subject. So at the intermediate level, when we talk about the other laws, we are covering 4 acts over there. The first chapter deals with the Indian Contract Act 1872. The second chapter deals with the Negotiable Instrument Act 1881. And the third is the GC Act, General Clauses Act 1897. And the fourth is the Interpretation of Statutes. Yes, these acts are very important because these are the general, you can say, laws which you find and which are applicable on every kind of the contract or the agreements related to the particular specific things is being covered over here. So you need to understand these laws very nicely in order to interpret the law to have a better conceptual understanding. So when we talk about the Indian Contract Act 1872, what comes in the mind? Oh yes, it covers only the General Principles Act being discussed under the section 1 to section 75 of the Contract Act, as well the special contracts being covered such as the indemnity, guarantee, bailment, pledge, and the agency. But you know, at the time when the act was enacted originally, it contained 266 sections with the wider scope of coverage of various kinds of the, you can say, the laws related to the contracts. Yes. If you see from section 1 to 75, it has been classified under the heading the General Principles of Law of Contract. Then further from section 76 to section 123, it dealt with the Sales of Goods Act. It deals with the movable property. Then further from section 124 to 238, it dealt with the special contracts, right? Whereby we have been discussing, or we shall discuss, since it forms the part of your syllabus, and at intermediate level, we shall be covering only this special contracts, that is the indemnity, guarantee, bailment, pledge, as well as contract of agency. And the last part, that is from section 239 to 266, that deals with the contract of the partnership. So if you see, due to the requirement of the necessity of the circumstances, the legislators felt that these two acts, the Law of Sales of Goods Act, as well as law relating to the partnership, is to be excluded and separated and enacted into a different act. Yes. So they have come out as the Sales of Goods Act 1930, as well as the Indian Partnership Act 1932. So presently, if you say about the Indian Contract Act, yes, it only contains the general principles of the contract, as well the special acts, as already been told to you. Yes, this is the scope or the coverage of the Indian Contract Act 1872. So when Indian Contract Act is discussed, what comes to our mind? It generally talks about certain types of rights or duties in being created. Yes, actually, the Indian Contract Act brings within its ambit the contractual rights that has been granted to the citizens of India. Okay, and it provides the right, duties, and obligation on the contracting parties. Again, I'm emphasizing on the contracting parties, they just lay down the rights and duties and obligations so that they will help them to successfully conclude their everyday life transactions, conducting to the businesses as well as companies, and moreover to the trade, commerce, and the occupation. So it is the important part of the mercantile law, or you can say the commercial law, basically. It is the foundation upon which the superstructure of modern business is being built. It affects every day more so trade, commerce, and the industries. It may be said that the contract is the foundation of the civilized world. So this is the basic intro about the Indian Contract Act. But when you see the Indian Contract Act, you will be finding that it is not an exhaustive law. What does it mean, exhaustive law? That means it is not a complete code in itself. It does not deal with on all the types of the contracts. It does not cover all the classes of the contract, in fact. you'll be finding that there are different laws regulating different nature of the contract. For example, yes, if you talk about the Negotiable Instrument Act. So for regulation of such type of agreement or the contract, the act that regulates these agreements are the
Negotiable Instrument
Act 1881.
In fact,
Yes.
We can also say that if we are saying that it's not an exhaustive act, that means every transaction that is happening, it's some kind of contract that is happening. So every kind of a contract cannot be covered in the Indian Contract Act 1872. That's why we are saying that it's not an exhaustive
Yes.
law.
Yes, if you talk about the law of partnership, it is governed by a separate act, the Indian Partnership Act. If you talk about the law relating to the movable products or movable goods, then of course the same. So Goods Act. And similarly, if you talk about any railways related act with respect to the carriage taking over or transferring over there's a different act, Railways Carriage Act. So everywhere there are different acts regulating the different classes of the contracts. So it is not an exhaustive law, right? Now the next thing is that it does not have retrospective effect. It means whatever the contract that has been made earlier before the enforcement of the act, on these provision of the act will not apply. So this is retrospective, does not have a retrospective effect. That means it's not different from being the past. Past contracts are being not governed under or being affected as per the provision of this Contract Act.
However, this line is not much of importance to you as of now since the act was formulated in 1872.
Yes.
So you don't have to.
But just only cover in order to know what is a retrospective, what is a perspective. So in order to that, I have just explained in the line, it is not having a retrospective effect. If it has been said, then whatever act has been covered earlier also will be covered by this act also. But since it's very clear and thought to you that it does not have any retrospective effect. Then next is whatever the principles of the Contract Act are being governed, they are being construed in such a manner that the parties are entitled to enforce their contractual rights in a reasonable way. Means here the parties lays down their own rights and regulation by framing the terms and conditions under the contract. You know, generally what happens, generally in any kind of the conduct or transactions or business, we lay down certain types of rights and obligation arising out of that particular act. But in the Contract Act, we only come up with the terms and conditions, and thereby party itself they create the rights and duties, how they can enforce that particular act. So here what they do, they just entitled to enforce their contract or contractual rights in a reasonable way, and even the court will not support an attempt to enforce them in an unreasonable way. They see that the parties are being not affected, and to the best interest of the parties, their interest is being safeguarded. So in a reasonable manner, they decide and they enforce accordingly the contractual rights of the respective parties under the contract. Then one of the most important aspect is that the Indian Contract Act lays down the two kinds of, there are basically two kinds of rights, you can say, right in rem and right in personam, which is known as jus in rem and jus in personam. This is a Latin terminology, right? So when we talk about right in rem, it means the right which is created against the whole world. Some kind of act you have done which give rise to the certain kind of rights and the obligation which can be imposed against the whole world. You enjoy your rights created out of this particular act. So you will be enjoying against the whole world. And the other right is right in personam. So what happens in such a case? Only the contractual parties are being affected and the contractual rights can be enforced against that particular parties to the contract. So Indian contract is basically giving rise to the right in personam. So whenever there is a contract, the parties, they are entitled to enforce their contractual right towards each other, none other than that. So it is a right in personam. Then these are the important aspects. Let me tell you a simple example just to understand how the contractual right is being, created against one or the other parties. So generally, you must have heard about a famous place, Ramgarh. Ramgarh was a place in a movie called Sholay. And there was one famous dacoit, Gabbar Singh. So what happened in that village, that J.N. Viru has come over there. And since he was dacoit, he always used to loot every goods that were available in the villages. So what happens in the village? The Rakhi festival is about to come. So what they did, they just thought to see whether every good is available, eatable item, consumable items are available or not. So what they find that the wheat flour was very much, you can say it was almost about to be finished. So what they thought, they just thought to go to the Lala. The Lala, you know, that the merchant.
The merch.
Yes, who used to just bring the
Sell.
goods from somewhere from the cities and in a wholesale and used to sell it to the villagers. So since this famous dialogue is there of that movie, कौन सी आटे की चक्की कौन सी चक्की का आटा खाते हैं ये रामगढ़ वाले. So it is a famous dialogue from the movie Sholay. So what happened that there was some that you can say that goods were about to be finished. So what they did, that Viru and Jay gone to the Lala and they entered into a contract for the supply of 50 quintals of wheat flours on a specified date due to the arrival of the the occasion, the festival. Yes. Now what happened if Lala fails to supply the same to the Jain Viru? Then what will be the situation? Here that right is being created and the duty has been arrived. Then one party has to fulfill his duty and other party has to avail his rights. So in that case, if Lala fails to fulfill his promise to supply the goods, in that case, Jay and Viru can sue Lala. So here just it gives rise to the rights and duties against each other. So this is right in personam. So in this today's session, Shraddha, we shall be discussing mainly upon the unit 1, which deals with the contract of indemnity and guarantee. And we shall also be discussing about the nature of the obligations and rights of each of the parties to the respective contracts, as well as the modes of discharge of the contract, as well as distinction between these two important terminologies. So let's start with the session. But before that, let's greet to our students. Manisha, hi Manisha, good evening. Aisha, Bhumika, Rajiv Kumar, Keshav, Komal, Sushil, Manav, Diksha. Very good evening to everyone and welcome to you all once again on the behalf of Board of Studies and on behalf of we the mentors for the session. Please make this session more and more interactive and it's an aim and object of these faculties also that you should learn something, and that is why we are here because through this platform, we are expecting that all students will be driving maximum benefits. Yes.
So in this session, since ma'am has already told you that we will be dealing with the contract of indemnity and guarantee, students, you must be aware that we have on the website of the institute, we have capsules for the subject. So today we will be teaching you through the capsule, and you will be in a position to understand that how the capsules are to be used even for understanding as well as at the time of revision. In these capsules, what you can do, you can even add some more points on your own because we have not incorporated everything in the capsule. So let's start with the session. So this is the contract of indemnity and guarantee, which deals with section 124 to section 147. The main aspects of this unit are the contract. So the main aspects of this unit will be contract of indemnity. We will dealing with contract. What is the meaning of contract of indemnity? What is the meaning of contract of guarantee? And since we are talking about indemnity and guarantee, so guarantee will certainly lead to one other party, which is your surety. So we will be talking about surety, and the nature of surety is liability. Then the meaning of what is the meaning of continuing guarantee, and if we are talking about the nature of surety is liability, then also we will be dealing with how the surety will be discharged, and if we are putting some kind of the obligations on a surety, then definitely he will be also provided with some rights. The way I'm saying, you can learn and memorize the things in this manner that you link somewhere all of these things, and this is like mnemonics and other things that you can use, or the flow, which will be helpful for you to learn things with. Understanding part, that's our work, and then you have to learn on your own. So the first is your meaning of contract of indemnity. Generally, if we see the contract of indemnity as well as the contract of guarantee, these are modes of compensation. What do we mean by modes of compensation? That there is some contract for which a person needs a further assurance from someone that in case of a loss, he will be indemnified. So, or he will be guaranteed by someone else. So these are modes of compensation. Once that loss has occurred, then who will be liable to pay in that account? So these are modes of compensation, both indemnity as well as guarantee. What happens is they seem to be very similar. However, there are certain differences between the two which we will be discussing. So the first is the contract of indemnity. If we see contract of indemnity, section 124. So I will be quoting the sections to you so that you are knowing that how to say. Once we are just listening to the sections again and again, it somewhere imbibes in our mind. However, at intermediate level, as you know, it's not necessary to learn the section numbers, but if you are repeating whenever you are reading, you are saying that contract of indemnity section 124 says so, so it will be somewhere in your mind. So contract of indemnity. What is this? A contract of indemnity is a contract by which one party promises to save the other party from a loss caused to him by the conduct of the promiser himself or by the conduct of any other person. This is simply given in the act. So, what does indemnity means? If we see, it is a security against the loss. Like I said, it's a mode of compensation. So, it's a security against the loss. And for what we are doing the security? To make good the loss. That means someone is fulfilling the loss that has occurred. That is to compensate the party who has suffered some losses. If you put it in a single sentence, then it will be somewhere like the term indemnity means security against loss, or to make good the loss, or to compensate the party who has suffered some loss. And the act says the contract of indemnity, as we have told you. So, a very important thing which comes here is that the loss should be caused either by the conduct of the promiser himself or by the conduct of any other person. Existence of loss is very important when it comes to indemnity. Just remember this line. Existence of loss is very essential when it comes to indemnity. Until and unless the promisee has suffered some loss, until and unless the promisee has suffered some loss, he cannot hold the promisor liable for the liable that please pay for me. You understand? What happens is, suppose there are two parties and the loss has still not occurred. The promisee cannot go to the promiser and say, please come and pay on behalf of me. So by this definition that we have seen and what we are talking about, there are at least two parties in a contract of indemnity. One is your indemnifier and one is your indemnified. What is the meaning of this word indemnifier and indemnified? A person, indemnifier और indemnified. Indemnified जो आपको promise कर रहा है कि मैं तुम्हें save करूंगा from the loss. A person who is promising that I will, indemnify. Sorry, I said it wrongly. Indemnify is the person who is being saved against the loss. जो loss से save हो रहा है. And indemnified is the person who promises to indemnify the person, मतलब जो दूसरे को save करेगा. So there are two parties. One is your indemnifier and the other is your indemnified.
Even indemnified is known as indemnity holder also.
Yes.
Right? There's a one thing, Shraddha, that when we talk about the contract of indemnity, basically, if you see the contract of indemnity, it comprises of direct engagement between the two parties. That means there is a direct connection, there's a direct engagement. Two parties are involved in a contract, and there where one of the party promises to save other from the harm or the loss caused to him. So one party who's promising to save and other party who's promised to be saved. So they are having a direct engagement in the contract. And this definition of the Indian Contract Act confines itself to the losses. What sort of the losses? Which are occasioned due to the act of the promisor himself or due to the act of any other person. Right? That means the parties, those who are involved, either due to the act of the promisor or due to the act of any other person. If this happens, if any loss is occasioned from such a act, then there the contract of indemnity may be arise to make good the loss of the other party.
So let's explain this concept with the help of an example. Mr. Krishna contracts to indemnify Ms. Meera against the consequences of any proceedings which Mr. Balu may take against Ms. Meera in respect of a certain sum of rupees 5,000. This is a contract of indemnity. How we can say that this is a contract of indemnity? So here Mr. Krishna is saying to Ms. Meera that I will save you against the consequences of any proceedings which Mr. Balu may take against Ms. Meera. And for what sum of money? It's 5,000 rupees. So she will be saved in case of if this loss occurs. So here Mr. Krishna is the indemnifier. What did we say? Who is an indemnifier? Promises to save the other party from the loss. So Mr. Krishna is saying that he will save Miss Meera from the loss, and Miss Meera is the indemnified or the indemnity holder.
Yes.
So the next part is,
one more thing is there, Shraddha. Sometimes a question is being asked whether marine insurance or the fire insurance is a part of the indemnity.
So what happens if we see any kind of insurance? In short, if we say any kind of insurance will fall under the scope of indemnity, contract of indemnity. But there is one more thing. First of all, we said there should be an existence of loss. And the second thing we can say is it should be caused by some human agency. There should be involvement of some human act. Suppose in case of a fire, in case of a natural calamity, since it's not caused by some human intervention or by some human agency, that cannot be covered. That kind of an insurance cannot be there, or that kind of an insurance will not be covered under a contract of indemnity. However, in the case of a marine insurance or fire insurance, it will be covered under a contract of indemnity. Similarly, remember this, a life insurance, since life and death are in the hands of the God, so a life insurance does not fall under the scope of contract of indemnity. So first of all, the existence of law should be there, and the second thing is that it is restricted to the cases where the loss has been caused by some human act or by some human agency.
Yes. Even in the case of life insurance, what happens? Insurer never promises to indemnify the insured for any loss on the death of a person. So that is why, and this is something out of control of the human, act. So that is why it is being not covered in the indemnity. So question is sometimes being asked on this also in MCQ based. It can be testing your understanding of the subject as well as the scope, what are all being covered under the law of indemnity. So this is one of the important aspects that you need to understand and to know.
One more important thing is like if you see that whatever we are teaching you is from the definition that you have read of contract, that a loss occasioned by an accident not caused by any person or an act of God natural event is not covered under the contract of indemnity. Then the next is your mode of contract of indemnity. A contract of indemnity is like any other contract, and it may be express or it may be implied. So there can be two types. One is your contract of indemnity can be expressed. When a person expressly promises to compensate the other person from loss, then it is an expressed contract of indemnity. And what will be implied? When it is to be inferred from the conduct of the parties, in that case, the contract of indemnity will be said to be an implied contract of indemnity.
Yes. Actually, whenever you read any law, you will be seeing there is a relation of one section with the other. First, we discussed what is indemnity. Now we are talking about what are the modes of formation of the indemnity. So there are two ways, two modes, express as well as implied. Express means either it can be in the oral form or in a written manner, something which the promisor has expressed. Okay. And when we talk about the implied one, implied which refers from the circumstances or from the conduct of the parties. Sometimes the circumstances of the case also reflect the parties without going into a contract. They have entered into a contract by their act, by their, by the circumstances it has been made that they have given their consent and they have entered into the fulfillment of the contracts. So it can be either through from the implied conduct of the parties or through the circumstances of the case. So these are the two modes.
So next topic that we will be taking is the essential elements of the contract of indemnity. A contract of indemnity, as I told you, is like any other contract. And it must also fulfill all the essential elements of a contract which you have read at your foundation level.
Yes, under section 10, if you remember at the foundation level, you must have read section 10. It specifies clearly what are the elements that makes any agreement a valid contract. So there you have come across with some of the important aspects given within itself under the section 10. And apart from that, there are other essential elements also that also need to be coexist with it, whatever the elements are given under section 10 of the Indian Contract Act over there.
There is one more thing which I would like to add. If you see, the Contract Act is the basis of any act, not only this, but any act. Even if you see the Companies Act or any other thing, though we are not, we don't directly say that the Contract Act is followed, but the Contract Act is the basis. So even if it's indemnity guarantee or anything, the same procedure will be followed for these kind of contracts also.
Those are the general principles and it is applicable on every kind of the contract that you enter into. So there are certain important elements that needs to be complied while entering into any kind of an agreement, whether it may be the special contracts also, whether it may be related to any other contract or related to any of the transactions under any of the businesses, or you can say under any of day-to-day life activities. They will need to check that the general principles of the contract has been complied with. So what are the essential elements of the general contract if we talk about? They are, if you see, there must be an offer and agreement. Yeah, offer and there must agreements. That means it comprises of offer and acceptance.
Then there should be an intention to create legal obligation.
Yes. Then consideration, again the very important aspect. Yes. Without consideration, there can be no contract. This all we have it except under certain exceptions.
Then the parties to the contract should be competent where we have read about the concept of minors.
Yes.
And they
unsound mind. Yes.
All those things are to be followed here also. And if there is an exception to anything, then we will be dealing with it. Then there should be free consent. And it should not be by coercion or undue influence. Also, such things have to be followed.
Consensus addendum. You should try to remember these words because this will make you a little bit different from the others. When you just link or take them Latin terminology used in your day-to-day, while learning or talking, then it makes a little bit of difference from a normal layman. So we just want that you should learn certain important Latin terminology also just for the knowledge purpose. So there's a consensus addendum should be there, right?
Then the object for which the contract is to be created, like agreement is done, has to be lawful. The
Yes.
object has to be lawful.
This is also again one of the important aspect, because anything which is unlawful, any agreement or contract, it should result into a void agreement.
And the contract should not have been expressly declared as void. Example, in the strain of trade agreements,
Yes,
in the strain
and
of
with
trade,
minor-
marriage.
Yes, with respect to the minor, specifically it has been declared that any agreement entered with minor is a void ab initio. So this has been specifically declared as a void. So you should know that what these agreements should not be specifically declared to be void under the Act. That also is to be taken into consideration. Then whatever
Then the terms of agreement should not be vague or uncertain. That's if this happens, then
if suppose if you're not sure what you exactly want to buy,
outcome.
Suppose you go into a market without considering which car you just want to buy, and you just go, I want to see a car. And suppose in that also, if specific, some company.
The car is not there, the flying cars or the cars running or something,
Yes.
something.
So it must be certain. Yes, it should be certain also. Something which is specific, so that accordingly with that you can proceed with that particular agreement.
And it should not be the contract should not be to do an impossible act.
Yes.
So the basic you have to follow. So we have just like told you that the contract must fulfill all the conditions, and in one of the conditions we told you that it should have a lawful object. So there is an example for it. Suppose there are in this example you can see there are three persons. One is A, B, and C. So A asks B to beat C. Go and does function.
And today's young blood, they generally do such a act some kind ki bhaiya jao se maar kya. Sometimes in the fun and frolic way also they just do this kind of act, chal jao se maar kya, main tujhe 1000 rupees dunga. It happens sometimes that way also.
And it says that promising to indemnify him against the consequences. Okay, that you go and beat him, and if something happens, I am there to save you, compensate. Yes. But this will not be, though it is an act of indemnity, but it cannot be termed as a contract of indemnity. And in this case, if B on being like if he goes and beats C, then and he is fined for some XYZ amount, then B cannot claim that amount from A, because the object of the agreement is unlawful.
So this is again the importance of the essential elements. This is also being required to be complied with whatever the general principles are there. So you should understand this thing, because sometimes a question may be asked with respect from indemnity point of view. As Shraddha said, it is the indemnity, but yes, since it is not fulfilling the requirement of the general requirement of any contract or the agreement, and that is why this contract is unlawful and it cannot be enforced.
So the next topic that we will be dealing is rights of an indemnity holder. So rights of an indemnity holder when sued. Okay. So section 125 of the Indian Contract Act deals with the rights of the indemnity holder. What happens in a contract of indemnity? The promisee. Who is the promisee here? The indemnity holder. When he is acting within the scope of his authority, he is entitled to recover from the promisor, that is the indemnifier, some rights. And what those rights are? All damages which he may be compelled to pay in any suit, all costs which he may have been compelled to pay in bringing, defending the suit, and all sums which he may have paid under the terms of any compromise of the suit. So it's not just in relation to any fixed amount. The fixed amount is there, but if there is something additional, then that also will be, the person he can recover it from the who? Someone reply, he can.
Yes, from indemnity. Yes, somebody
response, because you will be like, we are also sometimes when we are speaking indemnified.
Yes, it will be recovered from indemnifier. Okay. So you should remember in such a way that indemnifier is the first person who promises. okay, to save the other person.
Wait.
And indemnified is the other party, the second party who's
Like
being,
if I see
yeah,
indemnifier
and fight
is the first person
हाँ,
जो
save करेगा from the loss.
जो promise कर रहे हैं कि मैं तुम्हें save करूंगा. Fire. Okay.
Yes, Ms.
And
Bhumika has replied correctly. Yes, Ms. Bhumika, thank you. And even I'm looking that yes, students are listening to our session because we are looking from your side that you should ask the queries so that we may also know that you are able to understand what we are trying to get you. So please come up with your queries.
So, and first person है indemnifier जो बोल रहा है कि मैं promise करता हूँ कि मैं आपको save करूंगा किसी loss से अगर वो हो जाता है. और indemnified वो person है जिसको वो promise कर रहा है.
Yes.
Okay. तो इस person को money के लिए वो promise कर रहा है. So fire and fight.
Even Miss Arya has said promiser. That is also right because he is promising. So that is also right. But yes, here the parties are being named as indemnifier and indemnified. But yes, promisor is also right.
So who has said
Arya?
Arya. So Arya, there is one thing. Though you have used, your understanding is perfectly right, promiser. But while we are dealing with this concept of indemnity, it's better in the examination if you will be writing the word indemnified. She is not wrong, students. I'm just telling it from our experience. What happens is the correct terminology here will be indemnified.
Yes.
Okay.
And even other students have also given the correct reply. Dikshita, Rashita, very good students. And we are looking forward for your cooperation in such a manner only that you are seeing our lecture and you are able to understand the concepts.
So we are again and again saying that the person will indemnify the other person. But when the question arises that when will that person start giving the money to the other person? So when does the liability of an indemnifier, we said na indemnifier is the person who is promising. So when does the liability of an indemnifier commence? The act is silent on this one. But what happens through judicial pronouncement? What do we mean by judicial pronouncement? It's like the Supreme Court or the other courts are telling that in such a case, such and such thing will happen. Though it is not written in the act, but it will be equated as if the act is saying so, because then it becomes an act of interpretation. The courts have interpreted it in such a manner that the result has come out as judicial pronouncements, and these judicial pronouncements are very much binding in similar circumstances.
Yes, judicial pronouncements means the decision given by the apex court. And when any apex court, if you see from the central level, of course, the apex court is the Supreme Court. And if at the state level, suppose if it's the case which is gone up till only High Court only,
Yes.
so there that is the higher court. If the court give any sort of the judicial decisions or you can say any decided case laws, it will become a law under the similar circumstances for the others. So if the same conditions or same circumstances persist, so these judicial precedents are also taken into consideration for the decision making. They help in taking the decision to the courts. But it is not that it is a straight jacket formula or it is something like that.
Yes.
Every time they will follow the same decision under the same circumstances. It is not like, it's not a watertight compartments in fact. So it depends upon the circumstances also, but these judicial precedents also form the sources of the formation of the law. This also act like a law at many times by the courts being followed these decisions in many of the cases and the circumstances.
But you have given a good line here, justification or given in any case by court. Correct. So when does the liability of an indemnifier commences? We have been saying existence of loss is necessary. So when that becomes certain, then in that case, the liability of indemnifier will commence. So it says, as soon as the liability of the indemnity holder, मैम आप तो कह रहे थे indemnifier की बात कर रहे हो, फिर आप indemnity holder कहाँ से आ गए? Indemnity holder कौन था? Indemnified. क्योंकि जब इसको लॉस होगा, when the indemnity holder will be facing the loss, then only the role of indemnifier will commence. Yes. So as soon as the liability of the indemnity holder or the indemnified person becomes absolute and certain, pakka, in that case, the liability of the indemnifier will commence.
Yes. And before that, guessing any sort of the consequences or the result, that will not lead to the indemnity. So it's required that act should become absolute and it should become a certain, then only the commencement of the indemnity takes place. Right? So sometimes question may be asked in order to check whether indemnity, there's a rise of the indemnity in the given situation. So you need to check with this concept also, that yes, the liability of indemnity holder has been, you can say, has been decided or has been fixed or has become, a definite. Then only the liability of the indemnifier will be commencing.
So this can come even as a MCQ.
Yes, they can ask
that when does the liability of an indemnifier commence, and then they can give the options, and one option can be when, suppose they give one option as when
they enter into a contract,
or when the liability of the indemnifier becomes absolute and certain. One option can be this option. At that time, it should be very clear in your mind who is an indemnifier and who is an indemnified. So let's go further with the help of an example. A promises to compensate X. So A promises to compensate X with, he may suffer by filing a suit against Y. X has to file a suit against Y. And suppose what happens, then the court orders, X files the suit against Y. And afterwards, the court orders X that he should pay 10,000 rupees to Y. In that case, what happens? This liability of rupees 10,000. A only said to X na that, yes, I am promising you to compensate. So when this liability has become absolute and certain, in that case, now the liability of the indemnifier will commence. As the loss has become certain, this 10,000 rupees loss has become certain, X may claim the amount from A and pass it to Y.
Yes. The absolute, what does absolute mean? Absolute means without any condition. There is no restrictions, there is no certain condition marked for the fulfillment. It is absolute means certain and as well as without any restrictions or the conditions.
So moving on further. So this was our basic about the contract of indemnity.
Yes. Now moving to the next important contract is the contract of guarantee. Hope the indemnity is clear to you, because these two types of the contracts are very important. Because whenever the question is being asked, sometimes students get confused whether it is pertaining to the indemnity or the contract of guarantee. So you need to understand when does any contract may be an indemnity and when it is a guarantee. So let's now discuss about the contract of guarantee. बहुत सुना होगा यार, मैं गारंटी देता हूँ तो ऐसा कर ले. Many times we have heard from our friends, our relatives, they are saying, तो डर मत यार, मैं हूं ना, मैं तेरी गारंटी लेता हूँ, तू करके आ जा, तू ले ले पैसा, मैं चुका दूंगा, I'll pay on your behalf. Sometimes it happens, but in real sense, I'm telling you, this is a very, dangerous thing. Because once you, from the legal aspect, just think it, you are being tied into legal relations. But ठीक है, लोगों को पता नहीं है, they are not aware of the legal consequences. That is why you are being safe. Otherwise, you will be caught into the legal consequences. So my humble request is only never give guarantee to anyone. Otherwise, definitely you will be caught. So it is better to understand what are the legal aspects of the guarantee from the examination and academic point of view. This is one thing that I've just told you.
If you would have seen, banks always ask for a guarantee.
They ask it.
So it's not like that you just sign about it. It's actually legally binding.
Yes. So when we talk about the contract of guarantee, you see section 126, it talks about the contract of guarantee. First, you need to understand what this contract of guarantee means. If you see within the definition provided under the Act, it says contract to perform the promise. First thing is, it is a contract to perform the promise made. Okay. Second aspect is to discharge the liability. Kiski, of whom? Of a third person in case of his default. That means here you'll be saying case of his default means about some person is there, party is there who has not fulfilled his promise. In that case, the third party will either perform the promise what has been made by the party who has promised to do the act, or will discharge, the third party will discharge the liability of that person who said, I'm going to fulfill this you can say this condition or this some kind of liability which is arising out of that act. So this is basically the contract of guarantee. So if you see, it is basically a contract to perform the promise made, or you can say to discharge the liability of a third person who will come in case of a default. If no default, no rise of such liabilities or the promise to be made. But yes, if the default occurs, then he needs to perform the promise that he has promised to perform, or to discharge the liability for whatever he has given in that said act. So this is basically you enter into a, the legal obligations whenever you give a guarantee. It becomes your duty. It becomes your obligation to perform whatever has been promised to do in the contract of guarantee. Right? So there are, you can just looking at this definition given, you can easily make out that there are three parties, because we are talking about the third party also here. The debtor is a person in respect of whose the default the guarantee is given. Means he is the main person. If he defaults, he is not able to fulfill his promise. In that case, the guarantee given by the third person, that is the surety, is to be fulfilled. Then the next is the creditor. Creditor is again the person, important person to whom the guarantee is given. Okay? So there are three parties. Now,
so if we say the thing is the initial contract was between the principal debtor and the creditor, and this surety has stepped in so as to give some assurance to the creditor that yes, the debt which you are creating is paid.
Yes. So basically, you see there are three-party agreements. Means there are three agreements arising between these three parties, right? So if you see the principal contract, first is the principal contract which is arising between the principal debtor and the creditor. This is the principal contract. First is the principal contract. The main contract which is entered between the parties is the principal debtor as well as the creditor, right? Then it gives rise to the secondary contract between the creditor and the surety itself. Yes, if the principal debtor is not able to fulfill his promise, in that case, the contract entered between the creditor and the surety to compensate. Then the last is the implied contract. This is the contract between the principal debtor and the surety. In that case, whatever the liabilities has been fulfilled by the surety on behalf of the principal debtor, he will claim that loss, or you can say claim that damages from the principal debtor. So there is an implied contract between them also. So basically it is a three-party agreement, three agreements arising between all the three parties in the different manner in the form of principal contract, secondary contract, and implied contract. So you need to understand these relations also, how this relation is being developed among the parties, because this also sometimes is being checked to the way of the question. When does the, rights of surety is being arised? Yeah, what type of the contract is between the indemnity holder or you can say between this indemnity holder, in between the principal debtor or the creditor or the surety. So you need to understand this relationship also, and just to understand the nature of the contract over here.
So let's explain
let's
through
see
some examples.
Yes. You see here we have given an example for your understanding what is a contract of guarantee. If you see in this example, A is there who is requesting B to lend some amount to C, right? Now what happened?
I'm sorry.
Yeah, A is requesting B to lend some amount to B. Okay. Now A guarantees B that C will pay the amount within the agreed time. So you can understand, first you should find out who all are the parties in what capacities. If you just clear in your thought process, you will be able to understand the example also and the concepts also. So here what A is requesting to B, that means to lend. B is here creditor because he is requesting B to lend some amount to C. Okay, so C will be in the capacity of principal debtor, right? And A is since saying to lend, so he becomes the surety. So if A guarantees B that C will repay the amount within the agreed time, and on failing of C to repay the same amount, yes, then A, who is acting as a surety or the guarantor over here, will himself pay to B. So this is the contract of indemnity. Oh, sorry, contract of guarantee.
So
yes.
If I say in some other words or in a simple word, what I can say, B needed some money and he went to A, please give me some money.
Yes.
B said, okay, I will give you the desired money if you bring someone who can say that if you are not able, like if
someone can take your lab, instead your responsibility of payment.
So who's that person? You bring someone who will be paying on your behalf. If you are not able to pay, then I will give you this amount of 10. So the someone who has come is C and is the surety. B, who is giving the amount, is the creditor, and A is the principal debtor. Suppose now B has given the money to A, and this who is this person A does not pay in future, then C will be liable to pay. Here little bit of the party's capacity has been changed, but it's okay. Here A is the surety because on his request, B has lended the money. Oh, sorry. So this is how sometimes it happens. This is ma'am inadvertently, just to test your understanding of that she has done this thing. So we were looking if anybody has pointed out this thing, but yes, we are seeing, yes, one student is there. Yes, she has pointed out very rightly. Yes, ma'am. This here, A will be standing in the capacity of the surety because on his request, that creditor has lended amount to. Actually, what happens is, if you see the question on the first instance, you will be seeing that something else. But this same problem happens during the examinations also. Yes, absolutely. So read the questions properly, because just sometimes writing, it may also be done directly also. Yes, B has lended money to C on the request of A or on the guarantee of X. But what happens, sometimes the sentence framing is in such a manner that students get confused. So read whatever the question is given in the examination. So accordingly, you may come up with the right thing in the right manner. Okay, then moving to one more example to make you to make more clarity in the understanding. Yes, the next example is that A obtains housing loan here from LIC Housing. Fine. So here this what happens? B promises to pay LIC Housing that if the other party is not able to repay the whatever the amount housing loan that he is availed of. So it is again a contract of guarantee because here B has assured that if A fails to pay the housing loan, he will take the responsibility to discharge the liability of the payment of the loan amount. So here A is the principal debtor, right? It is very clear. And B is the surety who is promising, and LIC Housing is the creditor who is giving the loan. So again, it's very simple and hope it is clear to you all. Let's take one more example. Fine. Something extra is good sometimes. So let's take one more example here. X and Y, these are the two persons who go in a showroom
They just want to purchase a car. So X says to the dealer to supply the latest model of the car to Y. X agrees that if agrees that if Y fails to pay, then he will pay it. So in case of Y failure to pay, naturally the car showroom owner will discover or will recover the amount of money from Mr. X. Yes. So this is a contract of guarantee. Here what happens? X promises to discharge the liability of Y of the payment of the amount. So, and in case of the default on the part of the Y, the X will be liable to pay the amount to the car showroom.
So if we see that we can clearly see that guarantee is a promise.
Yes.
For what kind of a promise is to say it is? It is to pay the debt owed by a person in case the debtor is not able to pay to the creditor.
And that is the debt owed by the third person, who is the surety. Because here the surety is liable to repay.
Yes.
Okay, and that too on the fault of the debtor.
So it has always to be written or oral, or it can be any mode.
What? Pardon?
I'm asking the students.
Yeah.
So it has always to be, it can be just like this, or it has always to be written, or it can be oral also.
Yes, it can be. Any of the two modes are there always for laying down of any contract. Apart from if there is any legal formalities required to be fulfilled, that is also be taken into consideration.
For the contract of guarantee.
Yes.
Okay. So the next is your...
Yes, here this Bhumika is saying that X is in the capacity of the surety where Y is the principal debtor. Yes, if you see in the example, yes, since X has promised that if that Y fails, so definitely X stands in the capacity of the surety.
Yes.
Yes. And Y is of course the principal debtor. So absolutely right with Ms. Bhumika. And if you see what is the nature of the guarantee, as already discussed, tripartite agreement, already said, but there's a one thing that you should remember, that the right of surety is not affected by the fact that where the creditor has refused to sue the principal debtor, or that he has not demanded to sue anything due from him. So in that case, what will happen? In that case, the right of surety will still exist. He cannot say that that creditor has refused to sue against the principal debtor, or he has not demanded any sum due from him. So there will be existing of the surety right in that case also. Now moving to the next part is the consideration of the guarantee. Yes. Section 127. 126 dealt with the contract of guarantee. What is guarantee? How to be made? What is the nature of the agreement? That is being discussed over there. Now the consideration. As already said, that any contract without consideration is not enforceable. It is one of the important, essential element of forming any valid contract. Even nudum pactum means no consideration, no contract. Right? So here for guarantee is said that consideration is the requirement. That something is to be done for the benefit of the principal debtor. What something? Something can be anything done, okay, or any promise made for the benefit of the principal debtor. Some way it is benefiting to the, the principal debtor. So that will be considered as sufficient consideration to the surety for giving the guarantee. Okay, so let's try to understand through an example. It says that A sells and delivers goods to B, right? Yeah. Now C afterwards requests A to forbear to sue B for the debt for a year and promises that if he does so, A will pay them in default of the payment by B. Now A agrees to forbear as a requested. Simple example is this, saying that yes, A has sold certain goods to B, right? And afterwards C says, please forbear to sue B for the debt for a certain time period, and promises that if he will do so, and later on, if that B is not able to pay the amount, then C will pay for them. And if A agrees to forbear as requested, then this is something for the benefit of the principal debtor. So this will be considered as a consideration. So here you can say it is a sufficient consideration for the C's promise in the given example. So it is a valid contract. And suppose if the consideration is missing, then such a contract of guarantee will be void. Let's take another example to understand. Now suppose A sells and deliver goods to B, right? Now C afterwards, without any consideration, without doing any act or without promising anything for the benefit or to be done something for the principal debtor, he agrees to pay for them in default of B. So here there is a lack of consideration. So this agreement will be considered as a void. So consideration is required for the formation of a valid contract of guarantee. This is clear? Now let's see, there are certain essential features of a guarantee. If you are able to understand, okay, what are the important features in order to just understand whether it is a contract of guarantee only, just to sure yourself whether this is the same thing that whatever has been asked in the question, or it's the same, the contract of guarantee, not it is a contract of indemnity or any other contract. You need to understand what are the basic requirements to constitute the contract of guarantee. So here the essential elements, if you see, the first requirement is the principal debt. So if you see, the purpose of any guarantee, if you see, is to secure the payment of a debt. Why this contract has been entered? To secure the payment of the debt. Whatever the party has taken, the amount or the loan or some kind of debt that has been secure. Yes, if he is not going to pay, somebody, some other one will pay on her behalf. So this is to secure the payment of a debt. So it is of the essence of a guarantee. Principal debt is the essence of the guarantee. And if there is no principal debt, then there cannot be a valid guarantee. So this is the first requirement, that there should be a principal debt within that agreement. The next is the consideration. Already explained to you, consideration is very important in the formation of this contract. And if guarantee is given without this consideration, then it shall be considered as void. Okay. So contract of guarantee should also be supported by some consideration. This is the requirement. This you need to understand. Next important aspect is the existence of liability. So this is very important. Again, there must be some existence of liability or a promise whose performance is guaranteed. So this liability of promise must be such which must be capable of being enforced by law.
It should not be time barred.
Should not be time barred, should not be uncertain, should not be vague. So such types of things should not be there. So such a liability of promise, it should be, such which is certain and capable of being enforced and should not be time barred. So there must be existence of a liability or a promise. Next important aspect is the misrepresentation or the concealment. Many times the question has been asked on this concept related to the existence of the contract of guarantee. So if in this case, what happens if any guarantee which has been obtained by a means of misrepresentation? What is misrepresentation? We have already read under section 18 of the Indian Contract Act 1872. Okay. So whenever a guarantee has been obtained by a means of a misrepresentation made by a creditor or with his knowledge and assent concerning to a material part of the transaction. Matlab something, some information, some misrepresentation which is pertaining to the material part of the transaction, then such a guarantee will be termed as invalid. Yes. You should know that there should be no misrepresentation by the creditor. Second important aspect is that any guarantee given by the creditor by means of keeping silence as to the material circumstances. If he keeps silence, knowing that, yes, this is something which is at fault or which is not right.
It should have material circumstances, means it should have been communicated. Otherwise, it can lead to a wrong decision.
Yes. So he has kept silence as to the material circumstances. So that can also be, in that case, the guarantee will be termed as invalid guarantee. Right? So let's try to understand through an example this thing. Yes. Now here what happens? A engages B as a clerk to collect money for him. ठीक है? A ने B को hire किया. ठीक है? To collect this money for him. और जो B है, he fails to account for some of his receipts. So here A is what in the capacity? A आपका क्रेडिटर हो गया, कैसे पर्सन हो गया जिसने हायर किया बी को कि भाई तुम्हें क्या करना है कि तुम्हें पैसे कलेक्ट करने, यू हैव टू कलेक्ट सर्टेन मनी, एंड बी फेल्स टू अकाउंट फॉर सम ऑफ हिज रिसीट्स, सर्टेन कलेक्शन ही वाज नॉट एबल टू गिव अकाउंट फॉर,
एंड ये ट्रांजैक्शन हो चुकी है.
यस,
मतलब दिस इज a separate contract, we can say, between A and B.
Yes.
So he could not account for some of the receipts. B could not. So that thing has already happened. Now the story will start further, where the role and a surety will come.
Now A, in continuation of this act, he says, okay, you go and call somebody to furnish your security for the course of this act, for duly accounting and all these things. C gives his guarantee for the B's duly accounting. So here A was not acquainted of the past act of the, conduct of the B. And even this has not been told by, by A to C. Yes, earlier also he has conducted such a act. So here you can see B afterwards, if makes a default, then definitely here the guarantee will be invalid, because here he is concealed. He has not revealed, yes, by keeping silence as to the material circumstance. Earlier also he has been failed to account for certain receipts of the amount. So in that case, if he would have told this to the surety, then definitely no surety will come forward and give the assurance for the payment or take his liability. So he just keeps silent and just conceal the material, the situation in this material circumstances. And in that case, if again the default is being committed, then such a guarantee will be said to be invalid. Let's take one more example just to bring more clarity to the concept, because it is an important concept. Here A guarantees to C for the payment, right? For what? For iron to be supplied by C to B, okay? For the payment of certain amount, okay? Right? Now here what happens, B and C, they privately makes an agreement and they agree. They agree, yes, that B will be paying certain extra amount beyond whatever the market price has been fixed by them, or whatever the market price is going over there, they will pay some extra amount beyond that. So such excess they will be later on applying in the liquidation of the old debts. Okay. So this agreement is concealed from A, the surety. Surety was not aware that B and C have privately entered into any sort of the agreement between themselves in order to clear their some old debt. They have increased certain amounts beyond whatever the market price has been fixed for the particular supply of that particular goods. So this agreement is again this kind of guarantee. You can say it is invalid, and here A is not liable as a surety. So it is an invalid guarantee.
So no misrepresentation should be there as to material facts, as well as there should not be any silence as with respect to the material circumstances. In that case, the guarantee given will not be valid and the surety will be released.
Yes. Now, next to the other important, the valid requirement. Yeah.
Writing not necessary.
Yes, so already said.
Students have said that it is necessary. No, writing is not necessary. The guarantee may be either oral or written.
Yes. The next important aspect is joining of the other co-sureties. This is again important concept. So what happens where a person gives a guarantee upon a contract that the creditor shall not act upon until another person has joined in as a co-surety. Means there is a contract between them. If the other person joins as a co-surety, then only the guarantee will be given upon that contract by the person. So such a guarantee is not valid until yet till that other person joins in a contract of guarantee. So if that other person does not join, then that contract cannot be formed and it can be termed as invalid. So if something is prescribed, if that particular act is being done, if it is being said the act will be done only or guarantee shall be given only when other person has joined it as a co-surety. And if that other person has joined, the contract will come into an enforcement. And if it does not join, the guarantee is not valid. It has not come into existence. It is something against the law as per whatever the terms they have fixed for entering into the guarantee. So that guarantee will not be valid.
Students, you can refer these capsules. This is the February 2022 capsule and it is there in the repository, or simply you can just go to the website and from there you can directly go to the capsules intermediate level and in that paper 2 corporate and other laws, when you will open, directly click on the link and you will be in a position to see all the capsules of corporate and other laws that have been uploaded.
Yes, and one more thing, don't forget to refer the study material.
Yes.
It should not be just restricting yourself to these capsules. It is required to refer the study material so that you can read the detailed provisions once over there. Then only you will be able to understand what has been given in summary form. Then only you will be able to get the concepts. So read the study material first. And after reading the study material, you can refer these capsules. Beside with the capsule, these lectures, because many additional informations which are not there in the study mat or over here in the provided notes that are being discussed in the session itself. So that will be helping you in understanding about more and more things related to the concepts.
And if you want to make use of these capsules, then please take out a printout, or if you have the hard copy already with you, then write further things in that. If you see, we are not able to write anything on this because they have been protected. So it's better if you take out a hard copy, and then if you are writing your notes in that, then you can use it later on for your revisions.
Yes. Now moving to the next important aspect is the types of guarantee, right? So yes, here there are two types of guarantee, specific guarantee and the continued guarantee. When we talk about the specific guarantee, so it relates to only a single debt or related to specific transaction, right? So this can be only extended to a single act. Here the shortage liability comes to an end when the guaranteed debt is duly discharged or the promise is duly performed. And with the accomplishment of that particular act, the guarantee comes to an act. So this is a specific guarantee limited to specific transaction or a single debt. Okay. Now with respect to the continuing guarantee, it extends to the series of transactions. Means many transactions. There is a related series of transactions, but that will be keep on continuing, and every time it enter into a new transaction.
So within those series of transactions.
Yes, it will be a new contract over there. But yes, it will be extending for a series of transactions. It will be not ended just by doing one act, but it will be continued. But every time you just do it or you place any order with respect to the same agreement, it will be kind of a new contract. Then here it says that it applies to a specific number of, it does not apply to specific number, but to n numbers of the transactions. And here make the surety liable, okay, until the revocation of this guarantee is there. That means since it is a series of transactions, so here the liability will continue of the surety till the revocation of guarantee is there. And it applies not to the specific number of transactions, as already there are many numbers of the transaction within the series. And surety is liable for the unpaid balance at the end of the guarantee. Okay. When the guarantee is revoked, it is ended. At that time, whatever is the outstanding balance at that time, the surety will be liable to pay that particular amount, or the liability stands only for that amount only. This is a continuing guarantee. So let's take example to understand this aspect also. Now here you can see A guarantees payment to B. As here the guarantee is made with respect to the price of 5 bags of rice to be delivered by B to C and to be paid for in a month time. ठीक है, B delivers 5 bags to C and now C pays for them. So here you can see the transaction is completed. For a here you will be finding that only there the contest has been restricted only for the price of the first 5 bags. So you will be finding this is the contract of specific guarantee. Here A intended to guarantee only for the payment of this first 5 bags. That is to be delivered one time. If anything is done later on, then that will not be considered as a specific guarantee. Specific guarantee ends with the performance of the single act of transaction or that specific act.
So if he delivers one more bag, because he said that I will be liable only for these 5 bags of rice.
Yes.
If he delivers somehow after, supposedly if he delivers 7 bags or 8 bags, he is liable for the first 5 bags. So it stops with the thing that we have said. It ends there.
Yeah. Then if we see the example of continuing guarantee, now what happens on A's recommendation? He's the A's recommendation. A person is there. He's the landlord B, who employs C as his estate manager. So it was the duty of the C to collect the rent on every first day of every month from the tenants and to remit the same to the landlord on every fifth day of every month. So here A guaranteed this arrangement and promises to make good any default if made by the C, right? So here this is the contract of continuing guarantee because a continuous task, because every month he has to collect a rent and then he have to remit to the landlord. So there's a series of transactions, continuing act. So here you can see this is a continuing guarantee and here the short is liability continue until the revocation of the guarantee is there. Got it? So hope these two types of guarantees is also clear to you. Now moving to the next important aspect.
So we have till now learned that what is indemnity, what is guarantee, and in the concept of guarantee, there is one major person who has come into picture apart from the principal debtor and the creditor. Like for any transaction, a debtor and a creditor are necessary. Is the person surety, who is assuring the creditor that yes, your amount will be paid, and he is also giving a kind of assurance to the principal debtor also that okay, you take the amount, I'm there for you to pay for you. So the person who is giving all those sureties is known as surety, and we will be learning about the rights and the liabilities of the surety.
Even one question is there, Bhumika has asked, can you give example of joining of the other co-sureties? Yes, suppose if it happens, there is A and B, they enter into a contract of guarantee with Mr. D. But before enforcing that contract, A and B says to D, yes, we want Mr. C also to join as a co-surety for for enforcement of this contract of guarantee. So they can do it through the agreement because here the concept is there with respect to the co-sureties also. So it is being dealt under section 146, how they can define their liabilities over there. So through agreement, they can say, yes, the contract of guarantee will be done if the third person also joins as a co-surety. And if he joins, then such a contract of guarantee can be enforced. And if not, then such a contract will be invalid. Already I have told you in the earlier slides also, earlier notes also this part. So it is, I hope that Bhumika, it is clear to you. So if, I'm just seeing there.
This you will be learning later that what is about the specific amount and the whole amount.
Yes.
In this case, there is a concept of the co-sureties and co-guarantors and all those will come. So we'll be dealing with those also. So we were talking about the nature and extent of sureties liability. It has been given under section 128. Okay. So what happens is the liability of the surety is co-extensive with that of the principal debtor unless it is otherwise provided by the contract. So he is extensively liable for the amount or for the guarantee that is given along with the principal data until and unless the contract says otherwise. If the contract says otherwise, then it will not be so. There are some important aspects as to the surety's liability. So what are these? What section 128 said is that it's coextensive. So with that of the principal data, the first is this. Surety is liable for what the principal data is liable. So first is your
coextensive.
This
is the equally extended right of the creditors of this principal debtors to the surety.
Then we have said that the liability of the surety arises on when there is a default on part of the principal data. Okay. So default of PD is necessary. As soon as the principal data defaults in the payment or in the non-fulfillment of the contract, then liability of the surety, which we have said was coextensive with that of the PD, it will start and he will be liable for all those sums which the principal data is liable. So since we are saying it's coextensive, and then once the principal data has defaulted, the surety will also be liable for all the amounts which the principal data was liable. Okay. Suppose there is a, before the liability of the surety has to start, if there is certain condition that has been attached, then until and unless that condition is fulfilled, the liability of the surety will not start. So if there is a condition that is precedent for surety's liability, then in that case, the surety would be liable only when that condition is fulfilled.
Yes, even with respect to co-surety also, if this is a precondition, yes, that X should be also joining as a co-surety in the contract of agreement, then that condition should be first fulfilled in order to make that contract enforceable.
Then third, suppose due to a default in the document by which the this arrangement has taken place, there is a default in the document and the liability of the principal data ceases. Then the surety, then the liability of the surety also ceases.
Yes.
Then fourth, surety's liability continues when, even if the principal debtor has not been sued. Suppose the PD has not been sued, but that does not mean the surety's liability will cease to exist. No. He will continue to be liable for that debt. What does that mean? Even if the principal debtor has not been sued or he has been omitted from being sued, then also the liability of the surety will continue. That the creditor may choose to proceed against the surety first. And this is true only if there is no contract to the contrary. If the contract says that no, this cannot happen, you have to first sue the principal debtor only, then this will not hold good. Otherwise, the the creditor may sue directly the surety.
So read the law properly. Somewhere it is given certain kind of a restriction is being marked. Then in that case, the general law, whatever is given, will not prevail over there. Because here is said that unless there is an agreement, if something has been fixed through an agreement, only that thing will prevail. If it is not given anything, then whatever is given generally in the act, that will only remain in existence.
So we said that the surety is liable for whatever the principal debtor is liable. We can explain this with the help of an example. A guarantees to B the payment of a bill of exchange by C, the acceptor. The bill is dishonored. Then in this case, obviously, A is liable. So A is liable not only for the amount of the bill. he said that he will be paying for the bill of exchange, but will also be liable for any interest and charges which may have become due on it.
Yes.
Okay. The next is your
liability of two persons. So what happens sometimes where there are two persons in a contract with a third person to undertake a certain liability, right? And in that case, they also contract with each other that in the case of default of one of the other, one of them shall be liable. So in that case, what shall be the liability and who shall be liable? There, the liability of each of the two persons against the third person under the first contract is not affected by the existence of the second contract. So if you can see, the first contract is entered between the two persons with the third person. I will just make you understand through an example also, but you should understand there are two persons who are contracting with the third person over here. And that these two persons will also contract with each other that one of them shall be liable only of the default of the other. In that case, the liability of each of two such persons to the third person under this first contract is not affected by the existence of the second contract. Okay, though it may be that third person is aware of such existence or not. Now let's take an example in order to understand. So here you can see there is A and B who is having a joint and several promissory note to C. So let's take in such a way that there are A and B. These are the two parties, two persons in a contract. And now what they did, they contracted with the C, the third person, okay, to take certain liability, right? And now these both, A and B, also contract with each other that one of them, okay, one of them shall be liable only on the default of other. Either B will be liable on the default of A or A will be liable on the default of B. So they will decide this thing, okay, and they've entered into such a contract. So here basically you see that A and B either severally or jointly they have entered into the contract with the third person also. And besides with that, they have entered between themselves also into a contract. Now, if suppose here A stands in the capacity of surety, okay, then in that case, what will happen? Suppose if B defaults and C files a suit against A the surety, that in that case, what will happen? That A cannot take a plea that is not answerable to the suit filed by the C. Because you can see in the example, the fact that A made the note as a surety for B shall not to answer to a suit filed by C against A upon the note. He cannot say that I'm just the surety. You cannot file against me. It could not be done. Because it's simply saying here that the liability of each of two persons to the third person under this is the first contract. Under the first contract is not affected by the existence of the second contract. If here A is acting as a surety, he will be liable. He cannot say ki, no, yes, I am as a surety, I am not liable. This could not be done. Here the existence between these two people, the contract is also in existence and it is not being affected. So I hope you understood the concept where there is two persons, then how the liability may be decided and who shall be primarily liable in the given case.
I think before starting our next topic, which will be the discharge of a surety, let's give some respite to the students to grasp whatever they have learned and understood till now. So we will be taking a short break. Right now it's approximately 7:30. So after 10 minutes, we will be meeting you. Let's have a break for 10 minutes. So, dear students, welcome back.
Yes. So the next important concept
Is the discharge of surety. That how will the surety be discharged from his responsibilities? So there are various modes of revocation, or rather I should say discharge of a surety. The surety may be discharged by revocation, by conduct of the creditor, or on invalidation of contract of guarantee. So we will be explaining this, that how the surety will be discharged. So what is the meaning of that discharge? When will the liability of the surety will come to an end? In simple words, we can say जब उसने payment कर दी तो उसकी surety खत्म.
Yes.
But there are other modes also. So it has been primarily categorized by revocation, conduct of the creditor, and by invalidation of contract of guarantee, which has been further subdivided into parts. So when the mode of revocation is, when the discharge is by revocation, the first is revocation of a continuing guarantee by notice. What do we mean by revocation of a continuing guarantee by notice? It has been given under section 130 of the Indian Contract Act. The continuing guarantee at any time may be revoked by the surety as to future transactions. If you see, you can link it to the previous examples that have been given. So, the surety, suppose the surety has given a continuing guarantee. We just told you that a continuing guarantee is with respect to n number of transactions in a series. So, the surety may say that from now on, I will not be liable for further guarantees. So the example is, we are saying revocation by of a continuing guarantee. The surety can say that suppose of like 5 rice bags, it was a specific,
yes, specific transaction, specific guarantee.
Okay. Why I have written this example? It was a specific guarantee. But here we are talking about continuing guarantee. The surety can say that I am liable, suppose in certain date, say 1/7/2023. He says that I don't want to be a surety anymore and I will not be liable for
any further
guarantees. Yes. So his liability will end on this date. Prior to this, 1/7/2023, he will be liable for those transactions falling within his scope. After that, he will not be liable.
But yes, notice is being required to be served.
Yes.
That is to be taken care of.
So the example is X gives a guarantee to the extent of rupees 50,000. What is the meaning of the word here? To the extent. So that means extent, first of all, to the extent of rupees 50,000 for the loans given from time to time. So this here, the whole line makes it a continuing guarantee. First of all, it's not a single transaction because they are saying to the extent of rupees 50,000, which has been further necessitated by, supplemented and necessitated by writing that loans given from time to time. So this makes it a continuous guarantee. And A gave a loan of rupees 10,000 to B. 50,000 का हमने बोला था, and now they have given कि 10,000 का loan दे दिया. Once this loan was given, now he says that I don't want to be a guarantor anymore, and he gives a note. X gives a notice of revocation. So here I have given the date, or it can be said that after 10,000, he said that I don't want to be a guarantor or a surety for you anymore. So X is discharged from the liability, all liabilities to A, for any loan granted after the revocation, like after he has given after 10,000. Suppose now A gives more amount to B. Suppose he gives 5,000 more. after 10,000, and then he gives 5,000 more, X will not be liable for this amount. So X is discharged from all liability to A for any loan granted after the revocation of guarantee, but is liable to A for 10,000 on default of B. So if B doesn't pay, then he will be liable for 10,000, but not for this 5,000. Next, so first revocation is the revocation of a continuing guarantee by notice. Next is revocation of a continuing guarantee by surety's death. So now if the surety has gone to God for some reason, so obviously he cannot be liable for the acts that have been done after his death. So in this case, this is in relation to section 131. In the absence of contract to the contrary. Here also the act is saying in an absence of a contract to the contrary, the death of the surety operates as a revocation of a continuing guarantee. Here also it's a continuing guarantee. Because if we are not writing continuing guarantee, then with the specific transaction, the guarantee would have ended.
Yes.
So that's why they are writing about continuing guarantee. So the death of the surety acts as a revocation of a continuing guarantee as to future transactions. So the surety's estate remained liable for past transactions. If we link it to the explanation that we have just given to you with respect to this one, he was liable till a certain date. So the death, when the occurrence of death of surety has occurred, he is not liable for the transactions that will be happening after that date. However, he is liable. The surety will not himself come and pay for it, but his estate is liable for the past transactions. I'm just giving this. His estate is liable for the past transactions that have taken place before the death of surety. Okay, so you can use the same example to understand this point also. So revocation may we have by notice, by surety's death, and by novation. So what is the meaning of novation? Novation means new. In simple language, novation means new. A surety will be discharged of the original contract if a fresh contract is entered either between the same party or by other parties. The consideration being the mutual discharge of the old contract. If a new contract is added, and we have already said that he will be discharged if something new is added, so he will be automatically discharged because now something has happened, a new contract has been formed. So obviously, the surety will be discharged. The next point is by the conduct of the creditor. So you can like not for writing in the examination, but for understanding point of view, you can just see novation and variance in terms of contract, because variance in terms of contract is also like a new contract. So although these are two different things, because novation is under section 62 of the Indian Contract Act, which you have read during your foundation times, and the second thing, which is variance in terms of contract, is being dealt with section 133 of the Indian Contract Act. So when there is a variance in terms of contract, so when there is a variance in the terms of contract between the principal debtor and the creditor, because we know there is a principal debtor, creditor, and surety. So there was some contract, and now the contract has been somehow, we can say there is the terms of agreement have been varied without the consent of the surety. Surety se bina पूछे या उसके consent के बगैर, they have varied the terms of contract. In that scene, the surety will be discharged. But there is again one more point. He would be discharged He means the surety will be discharged only in respect of all transactions that are taking place after the variation. Before the variation, फिर वही बात है जो हम यहाँ पढ़ रहे हैं. Before the variation of contract, in the terms of contract, the surety will be live.
Yes.
So we can explain this with the help of example. A becomes surety to C for B's conduct as a manager in C's bank. Afterward, so B's salary shall be raised, and that he shall become liable for 1/4 of the losses on overdraft. B allows a customer to overdraw and the bank loses a sum of money. So in this case, once the salary has been raised without the and other things have also been added, without the consent of surety, that is A will be discharged of his suretyship from the date of the variance in the terms of contract. A is discharged from his suretyship by the variance made without his consent and is not liable to make good this loss. ये इस वाले loss की बात है. But before the variance in terms of contract, he will be liable. Next is discharge of principal data. Suppose the principal data, because the primary, if you see, the contract was between the principal debtor and the creditor. If the contract has ended between them due to XYZ reason, that the principal debtor is discharged, then obviously the surety will also be discharged. I'm sorry. Okay. The surety is discharged if the creditor enters into a fresh contract with a principal debtor, or by which the principal debtor is released, because in effect, what will be it was? It will be a kind of novation, because the principal debtor is discharged from the old contract and a new contract has been formed. Or, very important, or does any act of omission or commission, the legal consequence of which is the discharge of the principal debtor. Okay. What happens is, I'm just looking for the example. So what happens is, we are giving you 2 points. In this case, one is fresh contract. Fresh contract means a new contract has been formed. And the second is any act of omission. Act or omission. या तो उसने कुछ किया या कुछ नहीं किया. And what is the what should we say? What is the reason कि इसकी वजह से जो principal debtor है ना, वो discharge ही हो गया because of the act, doing this act, or because of the omission from doing this act, the principal debtor is discharged. So the surety will also be discharged from performing this contract. A contracts with B for a fixed price to build a house for B within a stipulated time. B supplying, and for this the B has to supply the necessary timber. C guarantees A's performance of the contract. B omits to supply the timber. That means now the principal debtor will also be discharged from performing this contract. So C, that is the surety, is also discharged from the surety. Next is discharge of surety by creditors act or omission impairing surety's eventual remedy. So what happens is, a contract between the creditor and the principal debtor by which the creditor makes a composition with or promises to give time to the creditor or the debtor, or promises not to sue the principal debtor, discharges the surety. obviously the act will also say unless there is a contract to the contract. Okay. So we can say that, let's go back to this slide. So he will be now again discharged. We can explain this with a diagram. Suppose there is the creditor makes a composition with the principal debtor without consulting the surety. In that case, so without consulting the surety, what will happen? We have always seen that if it is done without the knowledge of the surety will be discharged. Then the second point is, if the creditor under an agreement with the principal debtor promises not to sue him, then also the surety will be discharged. Till now we are reading that when will the surety be discharged? But there will be certain circumstances when we will be saying that in spite of this, the surety will not be discharged. So those cases have been dealt as under section 136 and 137. First is where a contract to give time to the principal debtor is made by the creditor with the third person and not with the principal debtor. The surety is not discharged. Let's explain this with an example. See the holder of an overdue bill of exchange, which was drawn by A for B. So A here is the surety for B and accepted by B. A contracts with M, a third person. So we have seen where a contract to be given, contract to give time to the principal debtor is made by the creditor with a third person and not with the principal debtor. So here M is the third person and in that scene the time is given to B. So A will not be discharged. A will not be discharged as a surety here. Okay. Second is the case where again the surety will not be discharged. Mere forbearance on part of the creditor to sue the principal debtor. What is the meaning of the forbearance? That to give some more time, to give some sympathy.
Some type of excuse you can say.
Yes.
It can be delayed by certain time period or it could not be done. Something, any of the conditions.
So the creditor is giving some kind of forbearance to the principal debtor. Usko kuch relaxation de raha hai.
Yes.
So they are giving some kind of relaxation to the principal debtor. Or to enforce any other remedy against him in the absence of a contract to the guarantee. This will, because he's giving some more time or some sympathy or some kind of compensation.
Any other remedy you can say.
Yes. This will not discharge the surety. Okay. We cannot term it as a novation or variance in terms of contract because only this is mere forbearance, some kind of relaxation is given. So it will be beneficial for the sureties also. It is not in any case undermining the fact that the sureties will still be liable to the creditor. So there is an example. B, principal debtor owes to C a debt guaranteed by A. Simple. The debt becomes payable. However, C does not sue B for a year. So forbearance is there.
Relaxation is given.
Has become for a year after the debt has become payable. A, that is the surety is not discharged from his surety share.
Still the liability is existing. The main thing is that where the liability or the performance of any promise is in existence, the contractor also will remain in that existence.
So discharge of surety by creditors act or omission impairing surety's eventual remedy. Students, we explained it on the other side. So this is this part. So it deals with section 139. If the creditor does any act inconsistent with the rights of the surety or omits to do any act which is duty to the surety and the eventual remedy of the surety himself against the principal debtor is thereby impaired, the surety is discharged. So what we can say, the creditor does any act. So he is doing an act which is inconsistent with the rights of the surety or omits to do any act. So inconsistent or omits to do any act which is duty to the surety. मतलब कुछ ऐसा करना चाहिए था जो उसको श्योरिटी के लिए, ठीक है, या फिर कोई ऐसा जिससे कि आपका श्योरिटी के राइट्स हैम्पर हो रहे हैं. And the eventual remedy of the surety himself against the principal debtor is thereby impaired. The surety is discharged.
Yes.
A bank granted a loan on the security of the stock in godown. The loan was also guaranteed by the surety. The goods were lost from the godown on account of negligence of the bank official. So this was on the part of the creditor, which was the bank, and then it has impaired the rights of the surety. So the goods were lost from the godown on account of negligence of the official. The surety was discharged to the extent of the value of the stock. So lost.
Yes. So generally it is the plain duty of the creditor not to do anything inconsistent with the rights of the surety. And surety is entitled after paying of the creditor to his indemnity from the principal debtor. And in case if the creditor acts or omits or deprives the surety of the benefit of this remedy, then in that case the surety is discharged. Because his rights get impaired, affected, he cannot derive the benefit out of the remedy that is available to him. So in that case, the surety is being discharged. And through example, I suppose this point is also clear to you.
And request you to read this point in respect to the fourth point, which was by the conduct of the creditor.
Now moving to the next important point is with respect to the invalidation of the contract of guarantee. Okay, so this is being given under section 142, section 144 of the Contract Act. So it says that when any contract of guarantee can be considered as invalid. So there are three circumstances stated in the Act being covered under section 142, 143 and 144. The first one is guarantee which has been obtained by the misrepresentation. Already said, in the case of misrepresentation, you have already been knowing what are the aspects related to misrepresentation being covered under the General Contract of Act under section 18. So you should also know what are all sorts of the acts that can be counted as a misrepresentation. So whenever a guarantee is obtained by misrepresentation, which is made by the creditor or with his knowledge and assent concerning a material part of the transaction, means something which is pertaining to the material part of the transaction, if anything has been misrepresented. So in that case, such a contract of guarantee will be invalid. Okay. Then second important aspect is guaranteed obtained by concealment. So here also, if the creditor, by means of keeping a silence as to the material circumstances, gives guarantee, but he makes to feel the surety that everything is fine and he does not say anything about any default or anything related to that material circumstances related to particular thing with respect to which the guarantee has been obtained. If we conceal the relevant fact, then in such case also the guarantee will be invalid. Third, the guarantee on contract that creditor shall not act on it until co-surety joins. These are all the important aspects that we have dealt under the essential elements related to the contract of guarantee. There also we have discussed all these important aspects and points. So unless and until co-surety joins, so such a contract cannot be obtained. So on obtaining a guarantee by a person upon a contract that the creditor shall not act upon it until another person has joined in as a co-surety, there in such case, the guarantee will be invalid if that other person does not join. If he joins, then in that case, the guarantee will be valid. But if it does not join and gives a guarantee, where there is a requirement of the joining of the co-surety over there, then in such case, such guarantee will be considered as invalid. Example, suppose here A is the person who engages B, okay, to collect money for him. The same example we have discussed over there also. And he fails to give account for some of the collection of the amount of certain receipts. So what happened in that? A in consequences, yes, next time you may not commit such type of thing. So kindly furnish your security for duly accounting in the future. C is the guarantor. Okay, he come over there and gives the B's guarantee. But since A was not acquainted, okay, A does not acquaint C about the B's conduct of his previous conduct. That earlier also he has done certain kind of misconduct with related to the performing of his duties. So this was not made known to the surety, the A. Okay, so in that case, you will see that B afterwards it makes a default, the guarantee will become invalid. Because there is the concealment. If the fact which has been revealed to the guarantor, then definitely guarantor would have not given the guarantee towards such a person. But yes, since this was concealed, this was not known made known to the surety, and that is why considering that B is the genuine person, so he gives the guarantee, and afterwards B again commits a default, then in that case guarantee becomes the invalid. Now coming to the next point is with respect to the rights of the surety. Now what are all the rights available to the surety? Generally, surety enjoys various rights against the following persons. First, against the creditor. Second, against the principal debtor. And third, against the co-sureties. These are the three parties and against which you are seeing the sureties enjoying the rights. So if you see against the principal debtor, we have given you a diagram. What are all sorts of the rights available to the surety against the different parties? So first, let's go with the right of against the principal debtor. So here you are seeing the first right that is available with the principal debtor is the right of subrogation. What does subrogation mean? Subrogation means substitution, the right of substitution. So what happened where a guaranteed debt has become due or default of the principal debtor to perform a guaranteed duty has taken place. Now, surety upon the payment or performance of all that what he is liable for, he is invested with the rights of the creditor that has been against the principal debtor. So what happens here? On the payment of the guaranteed debt or the performance of the promise by the surety steps into the shoes of the creditor. That means here the right of the creditor is being substituted with the surety. Whatever the rights that are being invested with the creditor is now being shifted to the surety. So this is right of subrogation, which is given under section 140. So then another important aspect is implied promise to indemnify surety. This is again the right of the surety. Okay. In every contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety. The surety is entitled to recover from the principal debtor whatever sum he has rightfully paid under the guarantee. Whatever compensation or whatever payment he has done, he can recover from the principal debtor. So he has got the right to indemnify himself. Whatever loss he has suffered because of the default of the principal debtor, he can claim the same from the principal debtor. Now let's see here an example. Now B is indebted to C. Okay. And A is surety for the same debt. Now C demands payment from the A and on his refusal sues him for the amount. Now, what will happen? A will defend the suit having reasonable ground for doing so, but is compelled to pay the amount of debt with cost. So, he can recover from B the amount paid by him for the cost as well as the principal debt. Here, the surety has the right. whatever cost he has given or whatever the principal debt he has paid on behalf of the principal debtor on his default, he can recover from the principal debtor the same cost as the principal debt. He has right to God to indemnify himself. The next right that is available with respect to the creditor against the creditor to the surety, that is right to security. Now, surety's right to benefit of creditor's securities. This is being covered under Section 141 of the Indian Contract Act. Now, here the surety is entitled to the benefit of every security which the creditor has against the principal debtor at the time when the contract of suretyship is entered into. Okay, and whether the surety knows of the existence of such security or not, and if the creditor is being lost, he get losses without the consent of the surety. If he get part with such security, then the surety is discharged to the extent of the value of the security. So if you see this point also, this right available surety is very simple. The surety is entitled to certain benefit, okay, against certain security which the creditor has against the principal debtor. Now, what happened in the contract of security? It's happened that that security comes to, it gets part with such security. Creditors get part with such security, or where the creditor losses such security, there the surety is also discharged to the extent of the value of the security, right? Because if the creditor is not having any security lying with him, how the surety is going to be get liable for that? So when he get any loss or he get parted with the surety is also being discharged to the extent of the value of the surety. So here is an example to make you understand this concept a little bit more clear. Now here C advances to a tenant B certain amount on the guarantee of A, right? Now that C also has further security which has been given by B on mortgaging of its furniture. Now C cancels that mortgage with respect to the mortgage of the furniture. Later on, B becomes insolvent and he defaults in the payment of the amount or the promised whatever has been guaranteed. And now C sues A on his guarantee. So here A is discharged from liability to the amount of the value of the furniture. Since here this mortgage of furniture is now no more in existence, this has been parted with or this is over with. So here C will be discharged with respect to that value of the security. But however, he is liable to advance that amount of 2 lakh rupees which is given as a guarantee of A. Now moving to the next thing is the next right is with respect to right against the co-sureties. This is also important one. But besides that, there are other 2 rights also, that are right to set off as well as right to share reduction. So if the creditor sues the surety for payment of principal debtor, suppose, right to set off. If the creditor, right to set off. Now in this case, what happens if the creditor sues the surety for payment of principal debtor's liability? The surety may have the benefit of set off, if any, that the principal debtor had against the creditor. This is as simple as something is standing on credit for the payment of principal debtor liability, then surety may have the benefit to set off against the creditor with respect to whatever the liability is standing with respect to the principal debtor. Next is right to share the reduction. The surety has right to claim proportionate reduction in his liability if the principal debtor becomes insolvent. So he has got the right that he can reduce in the proportion the claim wherever the principal debtor has become incompetent to get rid of their liabilities with respect to the payment. Now moving to the next important right that is available to the sureties, right against the co-sureties. So who are the co-sureties? Co-sureties means when the same debt or duty is guaranteed by 2 or more persons, such persons are called the co-sureties. So co-sureties are generally, as of normal, the provision which is given under Section 146 says that they are liable to contribute equally. So equality of burden is the basis of the co-suretyship. Now here there is an example that A, B and C are the sureties to D for the sum of 3 lakh amount, okay, lent to E. Now E makes a default in the payment. Now here A and B and C, all the three co-sureties, as between, they shall be liable between themselves to pay 1 lakh rupees each. Because what we said, they are liable to contribute equally. So they will contribute equally for the amount which has been defaulted. Now, further law under section 147, it says that the principle of equal contribution, as already we have explained under section 146, it is subject to maximum limit which is fixed by the surety to his liability. If they have fixed the maximum limit, up to that limit only the co-sureties shall be liable towards the surety towards their liabilities. Now, for example, A, B, and C are sureties for D. They enter into several bonds. Okay, in each of the bonds, they have fixed the different penalties. A have fixed 1 lakh, B 2 lakh, C 4 lakh rupees. Now, suppose if D makes a default to the extent of 3 lakhs, so again that equal contribution. So all the three A, B, C will be liable to 1 lakh each. Suppose now if I change here that suppose the D makes a default of the extent of 5 lakh rupees. Okay, in that case, what will be the liabilities? Since A has been limited to the maximum extent of the liability we fixed is 1 lakh. So A is going to pay 1 lakh only, not maximum than that. Then B and C, since 4 lakh B has read, so they will equally be distributed among B and C. And since B is also limited to 2 lakhs, so not more than that amount will be levied as a penalty on B. So A 1 lakh and rest B and C equally to 2 lakhs. So this is how the co-sureties, the liabilities can be shed off by the co-sureties towards the sureties. How surety can avail the payment or how they can avail their rights against the co-sureties. Now, we have discussed all the important provisions related to indemnity and guarantee, but still there are certain summarized way we have to go into the differences between these two terminologies, because in sometimes a question is asked to differentiate these two terms, contract of indemnity and guarantee. So let's summarize here. This will also give you more clarity plus the difference, so that you can easily, whenever a question or difference is being asked, you can come across with.
So when we were talking about the distinction between the contract of guarantee and indemnity, we would discuss, very good, Bhumika, you have given the correct answer. So it can be termed as a revision for you people. So just if you are fully aware of whatever we are talking, then let's revise together, and it will also give you a new perspective for the distinction between indemnity and contract of guarantee. So the first one is the number of parties that will be there in a contract.
Yes, let us to the students. Let's know, students, how many parties are there in the indemnity, contract of indemnity. Yes, we are looking forward for your answers. In the indemnity, how many parties are there? As well in the guarantee, how many parties are there?
So, okay. So the students, okay, very good. Correct. So you have understood. So there are two parties in the contract of indemnity and there are three parties in the contract of guarantee. The next is the nature of the liability.
Yes.
So in the contract of indemnity, there is the liability is primary and it's unconditional. However, when you see the contract of guarantee, the liability of the surety is secondary and conditional, as the primary liability is that of the principal debtor. Because if we see when he is not able to pay and everything, then the surety's liability arises. Okay. Then what is the time of liability in both the, very good, Rishita. So what is the time of liability? The liability in case of a contract of indemnity arises. Whose liability has to be arisen? Indemnifier's liability arises only on the happening of the contingency. We said that the existence of loss is very necessary in case of the contract of indemnity. Okay, and in the contract of guarantee, the liability arises on the non-performance of the existing promise. Okay, for the payment of a debt. So once that happens, what happens? In that case, the liability will start. So what is the time to act? So when will they will start acting on that liability? In the case of contract of indemnity, the indemnifier need not act at the request of the indemnity holder. However, in the contract of guarantee, the surety will act at the request of the principal debtor. Okay. Then the right to sue third party. In case of an contract,
can we say that it automatically arises, the right of the indemnifier?
If there is an existence of clause, obviously it will arise.
Yes. So there is no need to request. That automatically arises.
There the event will be the existence of.
Yes.
Okay. So right to sue third party. In case of a contract of indemnity, the indemnifier cannot sue a third party for the loss in his own name, as there is no privity of contract. Privity of contract when
there are no parties to the contract because of that.
And in case of a contract of guarantee, surety can proceed against the principal debtor also.
Yes.
In his own right, because he gets all the right of the creditor after discharging the debt. This means that once the surety has paid the debt to the creditor, he steps into the shoes of the creditor.
Yes.
For the principal debtor. Then he will not be acting as the surety. After paying the debt to the creditor, the surety will step into the shoes of the creditor and will become the creditor to the principal debtor.
And this is the right of subrogation. Because it may be asked in the MCQ, what is the right of subrogation? So you should know where the this surety steps into the shoes of the creditor. I mean, it occupies the rights of a creditor. So this is being said as the right of subrogation.
And what is the purpose of both the indemnity and guarantee? We said that both are modes of compensation. So in the case of the contract of indemnity, it's for the reimbursement of a loss. If we see in the case of indemnity, it's generally we are talking about the loss.
Yes.
But in the contract of guarantee, it's for the security of the creditor. Because in the case of the guarantee, there are three parties, one of which has to be a creditor, and obviously for the benefit, for providing some security to the creditor that his debt is secured.
Yes.
This contract of guarantee is there. Then the last part is the competency of the contract. We said that all the valid essential elements of a contract are applicable to the contract of indemnity. Okay. And if there is any exception, we have let you know. In the contract of indemnity, all parties must be competent to contract. However, in case of a contract of guarantee, there is a slight difference. In the case of a contract of guarantee, where a minor is a principal debtor, so the minor is a principal debtor, means for the benefit
is a beneficiary.
The contract is still valid. If you see, we are not putting any liability on the minor. We are just saying that we are creating this contract for the benefit of the principal debtor. That means the minor is the beneficiary.
Yes. But surety will not. If he is minor, then that case he will not. That will not be
a valid contract.
Yes. Yes. Even many students have given right answers. Even Rajiv Kumar has said he has in indemnity 2 parties and 3 parties in the case of guarantee. Well done. Even Arya has said that indemnified and indemnifier are the 2 parties in the case of the law of contract of indemnity. Very right and absolutely right. And we are happy to see that students are responding to the questions and they are able to understand the concepts. Though we have tried to cover many of the concepts through the help of the examples so that you can understand the concepts and to avoid any kind of confusion with respect to the concepts, because concepts are somewhere, they are near to each other. There is some slight difference and making altogether the sense, the difference. So it is better to read these kinds of concepts with the help of example to bring clarity to the thought process or the concepts given over here. Right, Shraddha?
And this brings us to the end of this session.
Yeah.
And this ends our topic of contract of indemnity and guarantee. Thank you for staying with us and studying so hard. We wish you all the best for the future classes and we will see you soon in the coming classes.
Yes, wish you all the best. Take care and
study well.
Yes, of course.
Okay.
Okay,
Thank
bye.
you.
Take care and have a good night.